Of the High Court, my lord, we have page 27. We have page 28. Sorry, page 27.
27.
Yes, ma'am. My lords, towards the bottom of the page.
27.
Yes, my lords. About 12 lines from the bottom, my lords, as one could see from the pleadings. My lords have.
Yes.
As one could see from the pleadings, the oral and documentary evidence and the judgments of the child court and the first appellate court that there is no material to show that government paid compensation to the plaintiff with reference to acquisition of plain schedule land. Even in the present petition, it is not the case of the government that it paid compensation.
But where is the reference to the material that you produced?
My lords, the reference that throughout, my lords, may have page 26, the submission. And then I'll take, my lords, we have annexed the material here also. I'll show the material. Page.
Report of this petition stating that 1.4 is passed by the land acquisition.
I can go through the documents. We have annexed them here.
What documents have you found?
My lords, showing our acquisition as well as possession of this land, my lords. We first have the award, my lords, which is annexed to P2 at page 48, my lords.
48?
It begins at page 48. This is the award.
Where is this?
My lord, this is award number 8 of 1958. Page 48, annexed to P2.
Where is the reference to this?
My lords, in the third line, my lords will see acquisition of survey number 225/3A.
Yes.
And then thereafter, my lords, we come to page 50.
Yes.
Apportionment, my lords, have the heading. Survey number 225/3A, 1.45 acres. This belongs to Pogati Jagannath Rao. It is his ancestral property. It has come to his 3A.
This is one. The next paragraph is 227.
My lords, I think the respondent's counsel is talking about the second paragraph.
Congrats. সকালে ফোন উঠাওনি
সঞ্জয় তুমি জিজ্ঞাসা করতে না রাত্রিবেলাও আমার ফোন বিজি থাকে কেন সঞ্জয়
না না এর বস আমি শুধু কাজ
কাম ডাউন স্যার কাম ডাউন ক্রাঞ্চি চটপটা কুরকুরে চটপটার সাথে সবাই পটে
This year.
Yes.
The other.
The applicant had separate.
Therefore, you say that for those lands, interest will be paid, not for this land.
Yes, my lord.
Because possession was not taken.
Yeah, that is other set of lands, other portion of this land. And then place it in the context.
Let us see what he has to say. To begin with, your suit relief itself is unheard of. Mandatory injunction to rectify the revenue record without first asking for declaration of title, no proof of title, no document filed, nothing, and the trial court gives you a declaration of title. You don't even pay court fee for it. So you pay court fee for a rectification by way of a mandatory injunction. And thereafter, there is evidence now to show that this land is acquired. Even if they did not take possession, once it is acquired, it is acquired. If you have a right to ask for compensation, that's a different issue. They never acquired this land. When there is a mention of it, this award is there.
No, who says that the entire out of entire property, just a portion was acquired? You say that in your plate. No, out of
You admit it's not that
it is a different acquisition.
No, where is that document? Did you file it?
You specifically say that out of the total 5.79 acres, 4.45 was acquired. Yes. And the balance remained with you. That is your specific contention in the plane. Yes.
Who has established that?
Yes,
No, that's not fine. No, along with your claim, did you file a copy of the award in relation to that 4 acres, 35 cents or acres?
With the government and there is no dispute. Even the government is saying so.
You approached the trial court for a relief. Substantiated it.
I specify something.
Where is the evidence to show anything at all?
My lords, may
And on what basis do you secure a declaration of title in a mandatory injunction suit?
May clarify one thing. The highlighting sides have proceeded on the basis that they have not proved their written statement. How can that be?
No, it is not on that basis. That is exactly what the High Court said. 29.
If your lordship sees the original claim that I filed, look at the specific amendment. For all times immemorial, the revenue records always showed my ancestors, later my father, and thereafter me as the possessor of the land. Land acquisition happened only with regard to a particular extent. Now, only one particular revenue entry was added in my thing, showing it an approach, not government land.
This decree cannot stand.
No, explain one.
Yes, my lords, my evidence was not before the.
Why do you want to remand, madam? Yes, sir. None of these documents are part of the civil suit.
Of Ray itself is misconceived. And the relief granted to you is less.
Revenue record, why can't it be corrected? Because they mentioned it as an approach, not government line.
We need
It is not government
maintain a suit for rectification of revenue records. You need to have something more than your mere ipsit.
No,
nothing, no documents whatsoever.
Look at the documents that I filed, minutes.
What did you find?
Kindly see, look at the exhibits that I filed along with my minutes. The printed data
of the registered holder.
The
recent, you don't know what that is. So who is examined to prove that?
But the MRO is examined, he himself is admitting that it is my land. The MRO says, yes, they are the ancestral property of this Pata land, and we have acquired a portion of it, remaining with them. And none of those documents are referred to here. If your lordship sees my, you don't produce any of these documents along with the. Where do you refer to these documents here in the plane? This hardly 2 pages. Claim for injunction to rectify. Yes, but it has the resettlement register, the revenue map.
There is a mention of it.
The exhibits are mentioned there. By show the High Court judgment, where it is referred to.
You just list of documents is one thing. Where is the plain pleading?
Nothing.
There has to be an agreement in the plea, is it not, to support the evidence?
The fact which the defendants themselves are admitting, minutes, it's not about me, minutes. Even they are saying it is in the revenue record, it is their own land. If they are saying 5 acres is my own land, minutes, there is a question of me again admitting it, minutes.
If the government in this appeal is to the judgment dated 7/11/2022 passed by the High Court of Andhra Pradesh at Amravati in second appeal number 1186 of 2011, confirming the first appellate court judgment of the learned judgment dated 5/3/2010 of the learned Roman 7, additional district and sessions judge within brackets fast track court, Vijayawada, in AS number 87 of 2009, whereby the first appellate court confirmed the decree granted by the learned first additional senior civil judge Vijayawada in OS number 851 of 2002. What is the date of the trial court decree?
And that's the date. The decree, my lords, is 15/3/2004.
15/3/2004. We find that the very substratum of this entire litigation, namely the suit on which it is founded to be defective in its very foundation, in its very inception, the said suit was filed by the respondent herein. Which respondent?
Deceased respondent. Respondent number 5 was deceased.
Respondent number 5 here.
Deceased.
Why is he shown as respondent number 5 if he was the sole plaintiff?
My lords, these are.
And the state government and the government deleted him, my lords, from the AIF party.
My lords, we have page 33. The LRs are 1 to 4.
One Koganti Jagannath, and then the LRs are 1 to 5.
No, but some Muslims have come in. I don't know what is that. So these are 1 to 4.
Let's, I am asked 3, because they are subsequent purchases of a portion of the land.
Was filed by, was filed by respond number 5. This is respond number 5 here. Koganti Jagannath Rao seeking a mandatory injunction for rectification of the wrong classification of the suit schedule land in the revenue records by changing it into patta land by showing it as patta land instead of government forum book. Find them,
Not government going to move, it's sure a road approach.
you don't know what your prayer also is neither here nor there.
It's sure a road approach.
As patta land, showing it as if plaintiff's patta land, showing it as the plaintiff's patta land. In effect, the plaintiff, the deceased plaintiff seems to have wanted a declaration of his title, but skillfully molded it as a suit for a mere injunction and paid court fee accordingly. However, the trial court, where is that decree? The judgment of the trial court
starts at page 82, my lords.
The last portion.
দাদি কারণ সে প্রশ্ন করেছিল শাড়ির দাম কেন বাড়ছে তারপর একজন অধ্যাপক ওই রানীকে নিয়ে একটা কার্টুন এঁকেছিল বলে তাকেও সে জেলে ভরে দিয়েছিল
বাঁচতে চাই বিজেপি দায়ী
Property and that he had gotten right title and interest over the suit schedule property. The declaration ought not to have been granted to the deceased plaintiff in a suit of having lost sight of this fundamental aspect. The first appellate court and the second appellate court deemed it appropriate to confirm the said judgment and decree. We are of the opinion that as the very judgment and decree of the trial court are unsustainable on fact and in law, the superstructure built thereon must necessarily collapse. The appeal is accordingly allowed, setting aside the judgments, all 3 judgments. The suit shall stand dismissed. Dismissal of the suit shall, however, not preclude the respondents who seem to be claimants under the deceased plaintiff to seek appropriate relief if they so choose before the proper forum in accordance with law.
May I also record my statement that the defendants in their written statement admitted my title.
You don't need to match your.
May I mention item 113, Your Lordship, as far back as in October, Your Lordship had said,
It will be there tomorrow also.
Yes, Your Lordship,
Today.
I'm the only person, Your Lordship, and conspirators who still
Going to hurt you on this aspect.
Item 31 minutes, the Sakshi matter was the contempt has been issued minutes. We're just seeking some time to counter identify yesterday minutes. Other parties are here also.
Very good. Item 31, then for the petitioner.
For the petitioner.
Seeks time to file a rejoinder.
3 weeks.
File a rejoinder. Either the counter affidavit filed by
The state and the commission.
filed by the state and the West Bengal, what is that? School Service Commission.
Yes, sir.
School Service.
Lordship, may I mention item 31 and 30.
List on 31 and 32. What will go?
Yes. 31
List on, how much time do you want?
was 3 weeks.
8, 25th March.
Lordship, may I mention item 35.
32 notice has to be issued.
What is the issue on the last day?
What is that already finished?
Lordship, may I mention item number 35?
What date did I give? 25th March. Oh, this is best.
Lordship, may I mention item number 35? This year,
You guys tell the matter. Call please.
so Hmm.